Well, good afternoon, everyone, and let me give you a very warm welcome to the first in our series of oil and gas CPD webinars for in-house lawyers. It was great to see such a good turnout for this afternoon, and we really hope you enjoy today's session. For those of you who don't know me, I'm David Smith, and I'm one of the directors at Burness Paul in the oil and gas team, and I'll be co-hosting today's session with my colleague and fellow director, Laura Fraser. Before I hand over to those who are presenting, I just want to make you aware of a few housekeeping points. You should all have been put on mute automatically as you entered the webinar, but if you could please just make sure that you keep yourself on mute throughout to limit any background noise, then that would be greatly appreciated. After the presentations, we hope to have a short Q&A session, so please do send any questions that you may have in via the chat function at any point, and we'll try to cover off as many of those questions as we can at the end. Please note that today's session is being recorded, and we will circulate the recordings of all 4 webinars to you following the final session on Thursday. We have 2 topics that we'll be covering today. Firstly, we'll be hearing from David Goodbrand, who will be presenting on data processing and international transfers, what you need to know to keep your data flowing in 2021. And David will be followed by Rebecca Ablett and Laura Fitzpatrick, who will be discussing how businesses protect their intellectual property and confidential information. By way of introduction to David Goodbrand, David is one of our partners in the technology and commercial team. He specializes in advising clients on outsourcing arrangements, IT projects, IP licensing, complex commercial contracts, fintech, and use of information. So without any further delay, I'll now hand over to David.
Thanks, David. That's great. I also head up our data privacy practice, which is one of the reasons I'm speaking today about our data processing activities. And we picked this topic on international transfers because we have received a number of queries from the oil and gas sector in relation to transfers over the last few weeks. Sorry, somebody's trying to get me on the Teams there. So that's the drawback from working from home. So what we're going to cover today is we're going to cover some of the fallout from Schrems 2, a case you may have heard about last summer, and also Brexit and what that means for transfers. We're going to have a wee look at the new standard contractual clauses, which you'll probably all get familiar with in the next few while. I'm going to touch on transfer impact assessments as well. So I think it's fair to say that over the last year or so, we've been largely all working from home. Access to data has been really key to ensuring our businesses continue to function and operate efficiently. It's also made businesses think more closely about their data flows, whether that be to external third parties who you may contract with to process your data, or even intragroup to other companies around the world and overseas. Personal data is often shared with third parties, so whether that be for banking or payroll and benefit services or cloud computing, all of these activities involve the share and transfer of personal data. And GDPR really is about wanting to protect the flow of data down the supply chain from organizations who are controllers of the data to their processors, and also further on down the train to sub-processors. Effectively, we want to make sure there's no weak links in the chain in terms of protecting personal data and private information. So I think as lawyers, we're probably all very familiar with Article 28 GDPR and what that means in terms of contracts between controllers and processors, including an obligation not to subcontract without the controller's consent, and ensuring that processing is only undertaken on the instructions of the party that engaged the processor. So I'm not going to dwell on that. What we're going to look at is transfers of data. And so what are the main points to consider regarding international data transfers? So if we go right back to basics, the GDPR essentially prohibits transfers of personal data to countries outside of Europe, and now following Brexit, UK GDPR prohibits transfers of data outside the UK, as it assumes such countries do not offer an adequate level of protection for personal data. Now, in the real world, that isn't practical. We all know that data transfers out with UK and Europe happen all the time. So the GDPR, whether that's the UK version of GDPR and post-Brexit or the old EU GDPR, they both permit transfers of data to third countries as long as appropriate safeguards are put in place to protect the data. So GDPR also covers the processing of personal data, sorry, only covers the processing of personal data. That's data about living individuals. It doesn't apply to any other sorts of data, whether it be business data, operational data, or confidential information. However, as personal data is very likely to be commingled with lots of other forms of data, it's really difficult to separate personal data from other data sets, which means in some ways GDPR is also often seen as a default mechanism. Because it's so difficult to separate personal data from other data, effectively, if you're dealing with a data set or data sets, GDPR is really the default standard, which I suppose could be seen as a bit of an overreach, but that's just the realities of how modern businesses operate. So let's look at the choice of safeguards available under the existing law for the transfer of data outside of Europe and UK. Many of you will know that there's an ability to transfer data to certain countries that are deemed to be adequate. So that's countries like Japan, New Zealand, Canada, Switzerland, etc. They are all deemed to have an adequate level of data protection. Therefore, there's not an issue if any transfers of data are going to these countries. Safeguards are really a way of guaranteeing that an individual's data privacy rights are protected, regardless of where the data is transferred to and regardless of where it's processed. Another safeguard that used to be able to apply is, you may have heard of, Privacy Shield. And that was a very specific safeguard that allowed the transfer of data from Europe to the United States. But following the Schrems II decision last summer, the courts ruled that that mechanism was no longer applicable. You can't validly transfer data to the US using Privacy Shield. So anyone that was using Privacy Shield had to find another way, another safeguard. And the most common safeguard that most businesses are using or continue to use is to use the European Standard Contractual Clauses. And they are a set of terms and conditions which, if adopted in their entirety, were effectively, until now, able to effectively guarantee an adequate level of protection for the flow of personal data. And that's through this binding contract, these standard contractual clauses, which were quite often appended to other agreements to ensure that they're bound into the overall transfer arrangements. They've been around for almost 20 years and are creaking at the edges, to say the least. And the European Commission published for consultation a new set of standard contractual clauses, which we'll touch on later. With the Brexit transition period ended, we're in a further transition period for data protection purposes. And looking at adequacy, the European Data Protection Board has recently published 2 opinions on the European Commission's draft implementing decision to see whether Europe will deem the UK to be a safe environment to have adequate protection for personal data. And the UK adequacy decision will be formally adopted, hopefully in the next couple of months, if it's approved by the EU member states acting through the European Council. So what this means in practice, if the UK is granted adequacy status, is that following adoption, any transfers of personal data from Europe to the UK will be deemed to be adequate, and therefore no other additional safeguards need to be put in place, such as standard contractual clauses, etc., which is a massive relief, because there could have been a huge repapering exercise to get new contracts in place, even intragroup arrangements for the transfer of data between UK and Europe. But hopefully, once adopted, the adequacy decision will mean that that will go away. One slight negative from well, more than slight negative, a negative from the Schrems II decision is that there was quite a lot in that decision just to think about. It was okay. The Privacy Shield was done away with; it was hurled to be invalid. But the courts also ruled on the current position under standard contractual clauses. And really, if you remember that all of this is meant to try and ensure the standards of data protection in relation to personal data as applied in Europe must travel with the personal data in effect to try and protect personal data no matter where it goes to or is processed. So under Schrems, the courts held that if you use these standard contractual clauses as your safeguard mechanism, you now need to assess your data transfers on a case-by-case basis and a country-by-country basis to determine whether the laws of the country to where the data is to be transferred or exported will adequately protect individuals' data privacy rights. The real area of concern driven by that Schrems case was whether the data may be accessed or intercepted by governmental authorities and other third parties on national security grounds. So thinking about that, what does that mean in practice for companies that might be relying on standard contractual clauses to transfer data to countries that are perhaps not deemed to be adequate, so the US being an example? Well, the European Data Protection Board, the EDPB, has now confirmed that this means that organizations will be required to undertake a new assessment called a transfer impact assessment before transferring data outside of Europe. This feels like another hurdle to jump over, albeit, obviously, as I said earlier, the sole intention is to try and protect the flow of data and individuals' rights and freedoms. So just having a contract with standard contractual clauses in may no longer be enough. You can no longer treat the inclusion of these standard contractual clauses as a simple box ticking exercise. So all types of international data transfers where the exporter wishes to rely on these standard contractual clauses, whether to a third party or to intergroup arrangement or whatever, we're now being asked to undertake our own assessments of the laws of the countries where the data is being sent. So that's you, the data exporter, are responsible for conducting due diligence and assessing the impact of the transfer, which it's going to be a hugely daunting task for many businesses to try and assess local laws in wherever their data is being exported to. In early November last year, the EDPB issued recommendations, and it said that as well as undertaking these transfer impact assessments, companies should also look to adopt supplementary measures to ensure that the data transfers are compliant with GDPR and with Schrems. And we'll look at some of these supplementary measures in a minute. I suppose the good news for organizations is that the recommendations do set out really helpful case studies accompanied by recommended supplementary measures that could be employed by organizations in order to ensure an essentially equivalent level of protection is guaranteed. So these case studies are actually quite useful. However, the example case studies provide that where there's no form of supplementary measure could ensure an essentially equivalent level of protection. So if there's nothing you can do to ensure that the level of protection is equivalent, then the transfers of data should not go ahead at all or should cease, which is pretty draconian when you think about all the data transfers that are going on across the world. So any organization making use of transfers of personal data outside of Europe or the UK now, that doesn't benefit from an adequacy decision from European Commission will need to undertake due diligence essentially before allowing their data to flow. Unfortunately, although these requirements are relatively clear, the effect of these changes is really complicated and will require some considerable effort in order to ensure that all transfers are taking place in a compliant manner. So I'm going to pause there, and I'm just going to put up on a few slides just to highlight some of the points I was talking about. And sometimes looking at a slide is an easy way of having the information sink in. So pre-Schrems, before the Schrems decision, if your data is being transferred from Europe to the rest of the world, there was various safeguards that you could use. If the country was inadequate, standard contractual clauses, etc. So this gives a flavour of the sorts of safeguards that were available. So let's fast forward to post-Schrems, and as you can see, Privacy Shield was done away with, so that limits the options of safeguards available in terms of what you can use to transfer data out with Europe. And also at the bottom, you'll see standard contractual clauses now need to be looked at with a transfer impact assessment, and potentially adding additional safeguards into your contracts, adding additional hurdles. And finally, for completeness, we're just looking at the post-Brexit scenario. And this is relating to transfers of data from Europe to the UK and the rest of the world. As I said earlier, we're hoping that the UK adequacy decision will come through in the next couple of months, which will mean any transfers of data from Europe to UK will be appropriately protected. So you can take it as read that that will happen, which is great news. But all of these other additional steps for any transfers of data from Europe or indeed UK to the rest of the world still need to be thought about. So where are we? What does that mean in practice then, and what do we need to do? These transfer impact assessments. The EDPB has put out a 6-step plan which they recommend you undertake to ensure that you've carried out appropriate due diligence. The first is to know your transfers, to really understand what data is flowing to various parties across the world. And that includes remote access from employees that are based out with the UK, out with Europe, and also to cloud storage. So it's quite wide. Step 2 is to verify the transfer mechanism, which is these safeguards we just talked about on there. So you have to identify one of those as being appropriate for your transfer. Step 3 is to assess the effectiveness of the transfer mechanism, which is to undertake these transfer impact assessments. And that's really, as I said earlier, to ensure an adequate level of protection, equivalent really to that which we enjoy in Europe and the UK. Step 4 is to put in place supplementary measures. So where the standard conditions alone don't provide effective measures or protections, you're being asked to supplement them with additional supplementary measures. And they could be like technical in nature, such as end-to-end encryption or pseudonymization, which is to depersonalize data sets. It could be contractual measures, so perhaps requiring the recipient to use specific technical measures to protect the data, or to require information to be disclosed if any public authorities or government agencies were to try and access personal data locally, those kind of things. And finally, organizational measures. And these may be measures taken by the data exporter to protect data flows. So maybe updating your policies in relation to data transfers, a clear allocation of responsibilities as to who's responsible for compliance activity in relation to transfers, and procedures for dealing with access requests, that kind of thing. So these safeguard measures are sort of a smorgasbord menu of options which you can pick and choose. And they're not exhaustive, but they do provide some helpful starting point when data exporters want to think about additional safeguards. Yeah, and as I said earlier, arguably, or more than arguably, these data transfers shouldn't go ahead or should be suspended until you're satisfied that the level of protections are in place. Steps 5 and 6 are procedural steps, and also to regularly reassess matters. So I'm not going to touch on them. So I mean, I know I've cantered through this particular section, and there's a lot in it, but I think it's clear that the EDPB has put a lot of thought into this and created a very comprehensive process which tries to provide a secure route to maintaining transfers of personal data to third countries. However, for its comprehensiveness, the guidance, in my view, is not very practical and will be extremely challenging for organizations looking to be compliant without grinding international trade and data transfers to a halt. The due diligence requirements for local laws in particular are rather onerous and are unlikely to be achievable by private companies alone. So we'll expect guidance will result in increased involvement from in-house legal teams, external counsel, etc., in relation to data transfers. That this obligation falls to businesses themselves rather than a central or government authority or one of the regulators, I think risks divergence in approach. Some people may take a very strict view of these situations and scenarios and what is adequate, and others may take a different view. So it will perhaps lead to some divergence when assessing laws of local countries. And given the sheer volume of transfers taking place, it's going to be really interesting to see how supervisory authorities actually manage compliance with all these guidelines. Albeit the UK ICO is slightly sitting on the fence at the moment in relation to some of this, because obviously the adequacy decisions going through and various other things are happening post-Brexit. So a lot to think about. I'm just going to quickly touch on the new standard contractual clauses, which I've mentioned earlier, as if life in data protection world wasn't complicated enough. I think in the next couple of months, these new standard contractual clauses will be adopted in Europe, which is great. The good news is that you won't have to do any immediate repapering exercises to swap out the new standard contractual clauses for the old ones, because we're given a grace period of a year to do that. But nevertheless, I think the new standard contractual clauses, once they land, will also impact ongoing contractual arrangements. I mean, there's a lot of positives in the new standard contractual clauses to be applauded. They deal with a variety of different data transfers that are not currently covered by the existing standard contractual clauses, such as processor to processor clauses or controller to processor clauses. And they adopt a very modular approach. So again, you can pick and choose the modules that apply to your particular contract or arrangement, which does provide some flexibility. So as a result, they look quite different from the current standard contractual clauses. And I think, again, it will take us some time just to get used to them once they land. They also do contain a number of onerous obligations and have slightly unrealistic expectations, such as where there's a sub-processor that's been appointed. So a controller appoints a processor, the processor then appoints a sub-processor in another country or whatever. That the sub-processor requires to notify the controller, but also data subjects. And they won't really have a relationship with the controller or data subjects because of their position in the chain of the controller, processor, sub-processor. So that's going to be slightly odd for a sub-processor to have that direct engagement with controllers. Look, we could go on for another hour or two on the new standard contractual clauses, but I will not. It's suffice to say there's a lot of moving parts here that need to be thought about. So just finally, some practical steps before I hand over. So all of this, the impact of Schrems 2, the guidelines from EDPB, Brexit, and potentially these new standard contractual clauses, all really point in one direction, which is it's probably useful to consider and review some of your key contracts that involve data processing or data transfers to ensure that they are up to date. And at the same time, because of Brexit and various other things, I know a lot of companies are revisiting their privacy notices and policies. They may be looking again at their intragroup data transfer agreements and their data processing agreements generally, and also the records of processing. So all of these changes, I think, mean that a spring clean might be required for your data processing contracts and policies. And with that canter through the very exciting world of data protection, I'm going to pass you back to David and Laura, I think.
Brilliant. Thanks, David. That was really helpful. I'm going to hand over to Rebecca Ablett and Laura Fitzpatrick. So Rebecca is one of our senior solicitors in the dispute resolution division. She works in our contentious IP and technology and media teams. Rebecca advises on a wide variety of IP and IT disputes concerning patents, trademarks, copyright, software, design rights, and confidential information. And Laura is a senior solicitor in the employment division, and she advises on the full spectrum of contentious and non-contentious employment law matters. So without any further delay, I'll pass over to both Rebecca and Laura.
Thanks, David. Hi, everyone, and thanks very much for joining us today. As David mentioned, I'm a senior solicitor in our contentious IP and tech team here at Burness Paull. One of the areas in which our team has seen a real growth over the last sort of 5 years or so is the insider threat. And what I mean by that is employees, consultants, or contractors misappropriating their employer's IP and confidential information. And we work closely with our employment team in these types of cases. So the insider threat is a huge issue which certainly doesn't show any signs of slowing down, and actually something which has become even more pertinent for all businesses against the backdrop of so many employees now working from home. And with this being such a big issue, organisations need to invest in resource to mitigate and manage the risk of such breaches. And hopefully today's session from Laura and I will provide some useful background and recommendations. So first we'll take a look at what preventative action businesses can take. While there are a number of different legal options which would be open to your business in the event that an employee or contractor is suspected of having misappropriated your IP, which we'll cover in more detail later on. Of course, as the saying goes, prevention is always better than the cure. So although it's doubtful that you can fully insulate your organisation from the risk of information being misappropriated entirely, you can mitigate the risk of it happening to a certain extent. And with that in mind, we've prepared a sort of checklist of general measures which should be considered. So firstly, identify and keep track of your IP and confidential information. I appreciate this may sound like a bit of an obvious recommendation, but understanding what IP you have within your business is vital to protecting it. As a business, you should know where your IP and confidential information is located, whether it's in electronic or physical form. And on that basis, we regularly advise clients to conduct an audit and compile an IP register. That register should be accessible by designated people within your workforce and should be reviewed and updated on a regular basis. And once you've identified your business IP, you can then consider what steps need to be taken to ensure it's properly protected and not at risk of being exploited by others. Secondly, safeguard and restrict access to confidential information. So if confidential information is not kept confidential, then there's obviously a risk that it will lose its confidentiality status. And once information is in the public domain, it's very difficult, if not impossible, for it to be considered confidential again. And for that reason, another important action is to safeguard and restrict access to your business's confidential information. So one way to do that is to ensure that your IT system has suitable divisions in it, so the information is available on a need-to-know basis only. All confidential information should be marked as being so, and more sensitive confidential information should be password protected. And that helps defeat an argument that an employee or contractor didn't know that the document or information in question was confidential. Another protective measure is to implement a categorization of documents where any documents over a certain category will be flagged and special authorization is needed to send those out with the company network. So what that means again is that any of these documents are sent out with the company network without authorization, that will automatically trigger an investigation, which helps organizations act quickly in the event of a breach.
So just following on from Rebecca's first two tips, the next step that we'd recommend all employers look to put in place is proper internal IT security protocols, and also alongside that, necessary encryption and access controls. So this is particularly important on devices which can be taken outside the workplace. And as Rebecca's touched on, most people are working from home just now, so this is all the more important. As part of this, we would recommend that you're keeping your workforce educated and up to speed on things like password protecting documents, password protecting their devices, and using appropriate and secure access routes and software. So, VPNs and things when they're working remotely. The other key thing that they should be aware of is how they should respond in the event that they're concerned about there being a security breach. We've certainly, well, everybody's aware that there's been a significant rise in the number of data breaches and hacks since the start of the pandemic. So it's really crucial that you're making your employees aware that they need to be as alert as ever and follow the relevant protocols that you have in place. The next tip kind of flows as well from Rebecca's comments about confidentiality procedures and policies. So we'd recommend that you're taking a proper review of these types of procedures and policies to make sure that they're adequate and they're also accessible to your workforce. So as Rebecca touched on, making sure that the procedures provide for things like restricting access, marking documents as confidential, and ensuring that people know what information they should have access to and limiting that where that's appropriate. As part of that exercise and taking as robust an approach as possible, you might also want to request key individuals to sign an acknowledgement confirming that they've read these policies and are aware of the procedures which are in place. Or indeed, you could make that part of the kind of general onboarding process when an individual joins the business. And just following on the procedures and policies point, you should also be reviewing your existing employee relations policies. For example, a disciplinary procedure to make appropriate provisions in there about confidential information and really just underlining to your employees that in the event that they do misappropriate that proper action will be taken. This is obviously even more important just now with so many people working from home.
The next tip is to educate your workforce about IP, how it can be protected, and the consequences if it's compromised, whether that's intentionally or unintentionally. So there's a number of ways in which that could be done. These include, firstly, providing regular training, whether that's from internal or external sources, and potentially ensuring that that's part of your new start induction process. We're often asked to run training sessions for clients following a data breach. And I know from training that we recently had as a firm that the ICO asked our firm to run, I think it's yearly training on the protection of information at work. Secondly, providing a letter to all new starts, informing them that they are instructed not to bring with them any material which may contain IP from another third party, for example, their former employer. So often there's such a focus on departing employees that the risks associated with new starts is forgotten or just perhaps not prioritised. And clearly you don't want to find your organisation on the receiving end of legal action as a result of information which a new employee may have taken from their former employer. Thirdly, as Laura touched upon, ensure IP protection policies such as confidential information and IT security are in place and regularly updated. Again, that's something that makes a huge difference when it comes to enforcement action, as they can defeat any arguments that the individual in question didn't know that the information was confidential or that they weren't allowed to take it out with the workplace. Another recommendation in terms of educating your workforce is to monitor and document compliance with internal IP protection policies. And again, as Laura touched upon, including whether or not employees can send documents to personal email addresses to work when outside the office. When we're instructed in matters involving the misappropriation of an employer's confidential information or IP, it's amazing how often the employee or individual in question claim that they sent the email in question because they needed to do that to be able to work from home. And again, having the robust policies in place means that you can prevent that argument from coming across. Next, enforce policies in the event of non-compliance and ensure that your workforce are aware of the enforcement options which are open to you as a business. It's incredibly important that your workforce are aware of the consequences if your IP is compromised by them and are made aware when any enforcement is taken by your business. And finally, just generally use signs around the workplace to inform staff of the rules and policies in place. Obviously, with so many employees working from home, reminders can perhaps be sent by email or sort of stored on any kind of centralized systems which all employees can access. Again, it's really all about raising awareness within your employees.
And another way to do that is to make sure that your employment contracts do contain robust provisions in relation to IP and confidentiality, both during the course of employment and post-termination. So where an employee is particularly senior, creates IP as part of their role, or has significant access to confidential information, we couldn't recommend more that you need to properly consider the extent to which the clauses in your contracts, well, do they exist, or do they need to be tailored and made more robust? And as we'll come on to discuss with the enforcement section of this, if you have that as a basis, you're in a much better place to then take action. And just an example of that would be that if somebody does create IP as part of their role, we would specifically recommend that you're ensuring your contract contains a clause which makes sure that the IP ownership will transfer over. And it's, you can have it in your contracts as the main point, but things like job descriptions and things should all be updated to make sure that employees are under no doubt about who owns the IP. And another similar protection that we would recommend that all organisations consider is to make sure that employment contracts include appropriate restrictive covenants. So although employees must observe certain terms that are implied into every contract, they're generally speaking limited in nature and don't tend to extend to the period after the termination of the contract. So as we've touched on, departing employees are often very well placed to take advantage of confidential information, strategic plans, customer and client details, or other information about their ex-employer's business. So, we know only too well that they might try and attempt to use this information for the benefit of their new employer or to set up a rival business. And it goes without saying that this has the potential to seriously harm a company's business. So restrictive covenants provide superior protection of a company's interests, with the following types being the most common. So non-compete, non-dealing, non-solicitation, and non-poaching. And the key thing really to get right from the outset with regards to covenants is their enforceability. So in broad terms, a covenant will only be enforceable if an employer can show that it has a legitimate proprietary interest that it's appropriate to protect, and that the protection sought goes no further than what's reasonable, having regards to the interests of the parties and also the public interest. And the reasonableness question is always an interesting one. And I guess our key takeaway on this point would be that when you are looking to put in place post-termination restrictions, you properly apply your mind to that process, and insofar as possible, you should be looking to tailor the restrictive covenants to the individual in question, because what's appropriate for one individual might not be appropriate for another. And being able to show that you've carried out that type of analysis is a really helpful aid when it comes to persuading a court that the company has genuinely and reasonably sought to protect its interests. So one other practical tip from the employment side of things is just to put in place a process by which you're asking departing employees to sign a letter just to acknowledge that they've not removed any material containing the company's IP and confidential information. And also within that letter, you can be reminding them of their post-termination restrictions, and it's just a way of addressing their mind to what they can and can't do following the termination of their employment.
The next point on our checklist is to be alert to the possibility of registering your IP as soon as practically possible. So different types of IP will have different requirements in terms of registration, protection, and enforcement. So for example, trademarks are only enforceable once registered with the IPO, whereas copyright protection arises automatically upon creation. So for that reason, it's always advisable to register your IP if that's possible. And that will put your business in a much stronger position when it comes to protection and enforcement. And the final point on our checklist is to review confidentiality clauses in contracts with third parties, and also to track the flow of that confidential information to and from those parties, such as customers and suppliers. So that can be done manually using a sort of nominated gatekeeper within your business, or using third-party companies such as ZoneFox, who that process can be outsourced to them. So what that means for your business is that you'll be instantly alerted to any anomalous activities, and you can address that issue at that stage rather than further down the line when the damage might already have been done.
So as Rebecca said at the beginning, obviously prevention is better than the cure. So what do you do if you find yourself in a scenario where there has been a breach of this, kind? So there are a number of different options open to businesses, some of which will be more appropriate than others, and much of it will come down to how confidential the information is and the circumstances in which it has been taken. When instructed in a data breach or a breach of restrictive covenants issue, we'll typically talk through the following options with the client. The first option, which is at the lower end of the scale in terms of costs and aggressiveness, is to issue a letter before action, basically seeking contractual undertakings that the relevant obligations will be complied with, and importantly, any information will not be exploited, and you'll usually include a confirmation that the information has been deleted. This is usually appropriate where the confidential information is at the lower end of the scale, so perhaps where the company wishes to protect it, but isn't prepared to protect at all costs, and a strongly worded letter in these terms can be appropriate and effective. In some cases, we just find that this gives the ex-employee or the contractor enough of a scare that the confidential information is protected, they return the undertakings, and the client can be satisfied with that route. The advantages are also that it's a cheaper and quicker option to pursue. Although saying that, the letters can be ignored, and there is no real way to know that the undertakings have been complied with. So really it all just comes down to the level of reassurance the organisation requires that the confidential information hasn't been compromised. And then the next two routes which Rebecca will go through go up in kind of aggressiveness and cost as well.
So as Laura mentioned, whilst a cease and desist or letter of action can be a really useful way of, essentially satisfying the employer's concerns, if that letter is ignored or if the confidential information in question is sufficiently serious that a letter might not be considered appropriate, then the next stage is for court proceedings to be raised. So those court proceedings can seek a number of different remedies from the court. In the first instance, in these types of cases, you'd be asking the court for what's known as an interim interdict, and that involves asking the court to issue an order preventing the ex-employee or contractor from breaching their restrictive covenants and from using the confidential information or IP in question. So one of the big differences between raising these kinds of court proceedings in Scotland rather than England is that the orders can be granted much more quickly in Scotland. And that's down to the fact that there's a potential for the order to be granted without the ex-employee or contractor having any notice of the court action. And what that means is therefore they're not going to be in court to argue against the granting of the order. So the first the ex-employee or contractor would become aware of the interim interdict, unless they have a caveat lodged at court, is when that order is actually served on them by messengers at arms, which, as you can appreciate, in itself can have a very powerful effect, having a messenger's arms turn up at your doorstep with a written court order and serving it on you. So if an organisation wants to move for an interim interdict to prevent the employee from using the misappropriated confidential information or IP, then it does have to move fairly quickly. It's possible for us to get the papers into court on the same day that we're instructed, but more typically we take maybe 24 to 48 hours to get everything in place. And the interim interdict will be sought as part of a wider action, which could include other remedies such as damages arising from the breach or any other appropriate orders, which might include the return or destruction of any kind of confidential or IP information. So finally, that's kind of the middle route. And finally, if the element of surprise in this type of case is crucial, or if you think that the individual is of such a nature or character that if given notice of your intention to seek an interim interdict, they might try and destroy any evidence, then obviously you need to look at escalating matters. And the sort of next option up would be to raise a court action seeking an order under Section 1 of the Administration of Justice Act 1972. And this type of order is more commonly known as a dawn raid, although now it's not actually carried out at dawn, but it still has the name of a dawn raid. So that's the most kind of aggressive option, but it's certainly the most robust. And it's always done without notice. Again, that's to avoid evidence being destroyed by the individual in question. So a dawn raid order provides you with the authority to enter the individual's house and take electronic devices and hard copies of the information which is covered by the order. So as you can probably imagine, this option does involve an absolute cast of thousands, and is expensive as a result, but certainly it can be warranted in certain circumstances where the information which has been taken is of a highly sensitive nature, and if the owner of that information doesn't want it being shared at any cost. So that is the third and final option, and certainly the most robust and most aggressive.
I know I always find it quite exciting when Rebecca comes over to me in the office and she's like, there might be a dawn raid, Laura. So hopefully those with a checklist and an overview of the enforcement mechanisms was a helpful starting point. I appreciate we've covered a lot. I suppose from our perspective, the key takeaways for you are to be proactive, ensure that you've got appropriate preventative measures in place in the event that you do find yourselves in a scenario where there's been a breach, react and enforce where it's appropriate to do so, and just bear in mind the timescales, because time is of the essence more often than not with these matters. So yeah, I hope that was helpful, and we're happy to take any questions and can hand back over to David and Laura.
That's great. Thank you, Rebecca and Laura. Some really great tips there on how we can go about protecting our IP and our confidential information. So as Laura mentioned, we're now going to move on to our sort of Q&A session. So if you haven't already done so and you've got any questions that you'd like to ask, then please feel free to submit those via the chat function now. We've actually had a few questions that have already come in sort of privately. So I think the first one's one for you, David, actually. So is anyone actually undertaking transfer impact assessments in the real world?
Good question. I think it's fair to say, because these recommendations are fairly new, it's not bedded down as to be standard practice absolutely yet. But we are actually, we've seen and received a number of transfer impact assessments asking our clients to complete in relation to various exercises. So people are doing it. It's just, I think, because this is recommendations and wasn't on the back of that came out in November last year, I don't think it's filtered its way through to all transfer activity as of yet. But and as I say, the UK Information Commissioner's Office is slightly sitting on the fence at the moment, but certainly the European regulators are behind this. Obviously, this came from the EDPB, which is the European body that's sort of charged with best practice in European data privacy aspects. So I think it's got legs, and but it's fair to say it's not being rolled out on an equal basis at the moment. But I think there is a genuine issue here, and I think data privacy is only going one way, which is for greater compliance and greater regulation, greater protection of our data. You can see that in the news every day about data breaches and various big global giants losing data and various other things. There's a lot more importance being placed on the privacy of people's information and the protection of information. So I think it's here to stay.
Brilliant. Thanks, David. Okay, so yeah, I think this one's probably one for you, Rebecca and Laura. Who do you think should be implementing the measures that you covered in the session today?
And thanks, Laura. It's an interesting one, because I think you kind of need a bit of input from so many different parts of your business. We would generally recommend that you have a kind of cross-divisional team approach to it, involving HR, IT, legal, compliance. So it's very much, taking intel from each sort of appropriate team within the business, but definitely cross-divisional.
Brilliant, thank you. Let's just see if we've got any more. Yeah, David, I think another one for you actually. When will the new standard contractual clauses apply in the UK?
Yeah, so there was draft standard contractual clauses released in November, and then there was a consultation period that was open, I think, till the middle of December for people to provide comments on what they saw in the new standard contractual clauses. I think it's safe to say there was quite a number of comments that were provided as part of that consultation exercise. Various interested parties did not think that the new clauses would work in all scenarios and all situations. So I think the European Commission have taken on board some of these thoughts, and my understanding is that the latest information is that the new standard contractual clauses will be released in the next couple of months, possibly even sooner, possibly possibly next month. So we'll watch this space, and we'll make sure we provide an update on our blogs, etc., as and when that happens. As I said, we have a 1-year grace period in which to put these into play. And the other thing is the UK ICO is not officially confirmed whether they would adopt the new standard contractual clauses. Obviously, this new ones are from Europe, but it would make sense for the UK to follow suit and align ourselves with what Europe is doing. But that's partly a political decision, so we'll wait and see.
Brilliant, thank you, David. Okay, I think we've possibly got time just for one more. I'm conscious that our session is obviously due to finish at 1:30. So I think this is probably another one for you, Rebecca and Laura. Do you think that there are any sectors or industries where issues around protection of IP and confidential information are more prevalent?
I think the answer to that is we do see it cropping up across all different types of sectors, and certainly the cases in which we have been involved in do span across a wide range of sectors. But I think it's probably fair to say that it's more prevalent and certainly enforced in very technical industries like the oil and gas industry, where a lot of the day-to-day work focuses on confidential technical information, procedures, etc. And there is so much technical expertise and competition within the marketplace. And certainly we have acted for, a number of oil and gas clients in these types of situations to date. So kind of answer is across a wide range, but we do see it being particularly prevalent in oil and gas sectors.
Great, thank you for that. Well, I think that's probably about all the questions that we've got time for. Obviously, if anyone does have any more questions that they'd like to raise sort of after the session today, please do get in touch, and I'm sure our speakers will be delighted to answer those. So I guess I just want to conclude by thanking you all so much for your time this afternoon, and hopefully you find the webinars really beneficial. A special thank you also to each of our speakers. So thank you, David, Rebecca and Laura. Fantastic presentations this afternoon. And just a sort of quick reminder to let you know that this the second webinar in our oil and gas lunchtime series will be taking place tomorrow at 12:30. So we're going to be hearing from Jamie Kerr and Nikki Weir, who are going to be discussing the movement of workers between UK and European offices and offshore installations. And then our second set of speakers will be Stephen Guild and Jamie Wilson from our DR team, who are going to be discussing some recent cases on climate activism. So sure to be a good session again tomorrow. If you haven't signed up for either of those sessions and you'd like to do so, I think there's going to be a link in the chat function, so you'll be able to sign up now. So thanks again, everyone. Hope to see you again tomorrow, and have a good afternoon. Bye now.
Thanks.